What are some preparations you should have to ease the worst case scenario going into a second relationship?
So understand that certain things get affected by marriage and divorce that you might not even know about. If you go into a marriage and you have a will, that marriage automatically voids your will. You don't even know that it's happened. It may still be sitting there, but in law it has self-destructed, like in the Mission Impossible series from the 60s. The marriage has dissolved the will. The presumption being that since you're now married, you probably would have wanted to change it, but knowing that you are forgetful, the law does the thinking for you. Be very, very careful. A lot of people don't understand the day they get married that suddenly they don't have a will. And if you die without a will and you're married and you have no kids, your spouse gets everything. So a lot of folks don't understand when they get married, and that can apply to a second marriage, a third marriage, a fourth marriage. A lot of times, even the lawyer who prepares your will sometimes doesn't tell you that. So you need to be very conscious of that. The first thing I ask people when they separate is, do you have a will? Because a separation or a divorce, ironically, does not nullify your will. So the fact that you are amorous and you get married, the law presumes that you become Forrest Gump or the female version thereof and you forget everything, so they automatically void your will for you. But when you separate or when you divorce, that will that you had before when you were married that probably says, leave everything to my spouse, is still alive and well. And if you drop dead the day after you catch him or her with the Dallas Cowboys or the cheerleaders, or a week later, or a year later, or 10 years after the horrific legal battle and you haven't changed the will, they'll still get what the will says. And when you acquire a new family, then you get into the whole dynamic of what happens if you pass? Do you have kids from the first family, kids from the second family? Do they have a right to take under the will? What if you exclude them from the will? They have dependence rights under Part 5 of the Succession Law Reform Act. So even if you decide that you're going to cut out those kids your ex-spouse never allowed you to see for the last 10 years, they may still be able to challenge your new will because you didn't provide for them and they're still dependents. So under the Succession Law Reform Act, they can challenge the validity of the will. So you need to plan this stuff out. Again, you need to talk to someone who knows this stuff sideways in their sleep. It is not a place for first-timers. It's not a place for donut shop lawyers. It's not a place for your cousin Phil who just got his law degree and wants to do real estate law. It is a place for someone who's been down this road 1,000 times.